Hello students, I am Dr. Harpreet Kaur from Army Institute of Law, Mohali. I'll be discussing with you the topic of non-enforceability of directive principles of state policy, no longer impediment in the development goals. Introducing the topic, directive principles of the state policy acquires an exceptionally huge responsibility under the steady gaze of the formation of any law assortment in India, which necessitate the need for these standards and provisions while confining the quality. At the end of the day, they are a co-direct for the legislatures and executives of the country. They protect the perfect structure of the Constitution encapsulated in their introduction, which is justice, social, economic and political, freedom, fairness and society. The concept behind the directive principle of state policy is to create a welfare state. In other words, the motive behind the inclusion of DPSP is not establishing political democracy. Rather, it is about establishing social and economic democracy in the state. These are some basic principles or instructions or guidelines for the government while formulating laws, policies of the country and in executing them. The idea of directive principle of state policy is very much protected in Article 37, which expresses that the provisions contained in this part will not be enforceable by any court. However, the standards set down are in any case crucial for the administration of the nation, and it will be the obligation of the state to apply these standards while enacting the laws. Despite the fact, as clarified by the above proclamation, that these principles are not enforceable, non-enforceability doesn't make them inadequate or outlandish. Sir B.N. expressed that these standards had an educational worth which is essential to remind the individuals with incredible impact what the real purpose of our nation is. All the course of action in Part 4 fuse with the goals of the welfare state, that is, India. Further, Dr. B.R. Ambedkar outlined the quintessence of these standards that the administration needs to respond in due order concerning these principles before the electorate as a political decision enhancement resolution. Second, these standards helps our court while choosing the different sculptures identified with the regular government assistance of the overall population. These decisions ought to give way for drafting a resolution to avoid the clashes between the national interest and the interest of the political parties. Coming to the background of the directive principles of state policy. The idea of directive principles of state policy was taken from the Irish Constitution. Our creators of the Constitution were truly inspired by the Irish patriot development. It additionally found the regular starting point in the Nehru Report of year 1928, All-Party Conference Committee Report of 1928. This provision was later upheld by Motilal Nehru and Sapru Report of 1945. The Sapru Report was formulated to determine the issues relating to the minority group that Indian political parties decided to tap. It was set up by the board which was led by Tej Bahadur Sapru, a well-prestigious legal advisor at the main gathering of the anti-party conference in year 1941. This 343-page long report had an area of key rights like protected antecedent archives that went before it, like the Nehru Report of 1928, which had partitioned these rights into two sections, that is, justifiable and non-legitimate rights. The division of these basic rights was promoted by Sir Benigal Rao, an Indian civil servant and a legal scholar. It established a constitutional framework which was subsequently acknowledged. We have two classifications of key rights. While the enforceable part is remembered under the Part 3 of the Constitution, non-enforceable were consolidated in Part 4 as order standards of the state strategy with no assurance or confirmation to be upheld using any courtroom. Directive principles of the state policies look like the instrument of instructions given under the Government of the India Act of 1935. Dr. B.R. Ambedkar expressed in his words that the directive principles resemble the instrument of guidelines which were given by the Governor General and the governors of the states of India by the British government under the Government of India Act of 1935. What is now called as directive principle is simply another name of the instrument of guidelines. The main contrast is that these directive principles are guidelines to the council and the official. He likewise portrayed them as a novel component of the constitution. Directive principles of state policy set out the principles, destinations of the state, aside from the standards for the state to make the rules and strategies. They focus on a just country, understanding the advancement of the residents, sorting out town panchayats, giving free legitimate guidelines to economically vulnerable individuals, executing or creating uniform civil code, giving great assistance, and so forth. They separate a welfare state from a police state. They are embedded to keep up the soundness of the government as ensured in the preamble. Now, I'll be discussing with you the nature of the directive principles of the state policy. The nature of the directive principle of state policy can be explained via Article 37. The provision contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Thus, directive principles are not enforceable by any court. That is, no court can enforce the government to enforce these principles or make the laws regarding them. But mere non-enforceability does not make them useless. For the following reasons, this part has become an important part of the Constitution. First is, Sir B.N. Rao believes that these principles had an educative value. This educative value was for reminding those in power what the aim of Indian polity is. All the provisions in the part encompass the goal of the welfare state, that is India. Though these principles are not legally enforceable, they do have a political justifiability. As put by Dr. B.R. Ambedkar, the government has to answer for them before the electorate at the election time. Third, they help the court in the interpretation of various statutes. The interpretation shall be such that the statutes are not in conflicts with them. They also help the court to determine the scope of the fundamental rights. Thus, in case of Air India Statutory Corporation versus United Labour Union in 1997, the Supreme Court has rightly observed that the directive principles are forerunners of the UN Convention on the Right to Development. They are embedded as an integral part of the Constitution, and that they now stand elevated to inalienable fundamental human rights. Though non-justiciable, they are justiciable by themselves. The feature of directive principles of state policy are as follows. Directive principles of state policies are not enforceable in a court of law. They are made non-justifiable considering that the state may not have enough resources to implement all of them, or it may even come up with some better and progressive laws. It consists of all the ideals which the state should follow and keep in mind while formulating policies and enacting laws of the country. The directive principles of state policy are like a collection of instructions and directions which were issued under the Government of India Act of 1935 to the Governor of the Colonies of India. It constitutes a very comprehensive economic, social, and political guidelines or principles and tip for a modern democratic state that aimed towards inculcating the ideals of justice, liberty, equality, and fraternity as given by the preamble. The preamble consists of all the objectives that need to be achieved through the Constitution. Adding directive principle of state policy was all about creating a welfare state which works for the individuals of the country, which was the absent during the colonial era. Now I'll be discussing with you the types of directive principle of the state policy. The Constitution itself doesn't characterize the directive principles of state policy. For better implementation of the provisions and based on their substance and headings, they are generally arranged into three classes: socialistic principles, Gandhian principles, and the liberal intellectual principles. First, coming to the socialistic principles. They emphasize giving better structure to monetary and social equity and setting out the system of a vote-based communist state. These likewise promote communism. They direct the state through Article 38, Article 39, Article 39A, 41, 42, 43, 43A, and 47. Now, Article 38, to promote the welfare of the people by securing a social order permeated by justice, social, economic, and political, and to minimize inequalities in income, status, facilities, and opportunity. Article 39, to secure the right to adequate means of livelihood for all citizens, the equitable distribution of material resources of the community for the common good, prevention of concentration of wealth and means of production, equal pay for equal work for both men and women, preservation of health and strength of the workers and children against forcible abuse, and opportunities for the healthy development of the children. Next, we have Article 39A, to promote equal justice and provide free legal aid to poor. Article 41, to secure the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. We have Article 42, to make provision for just and humane conditions of work and maternity relief. Article 43, to secure a living wage, a decent standard of living, and social and cultural opportunity for all workers. We have Article 43A, to take a step to secure the participation of workers in the management of industries. Article 47, to raise the level of nutrition and the standard of living of the people and to improve public health. Now coming to the Gandhian principles. They portray the Gandhian philosophy of reproduction given by Sri Mahatma Gandhi during the national development. It is a portion of his thoughts are consolidated in directive principles of state policy, and they direct the state through Article 40, 43, 43B, 46, 47 and Article 48. Now coming into detail, Article 40 is to organize village panchayat and endow them with the necessary powers and authorities to enable them to function as unit of self-government. We have Article 43, which is to promote cottage industries on an individual or cooperative basis in rural areas. Article 43B, to promote voluntary formation, autonomous functioning, democratic control and professional management of cooperative societies. Article 46, to promote the educational and economic interests of SC, STs and other weaker sections of society and to protect them from social injustice and exploitation. Article 47 to prohibit the consumption of intoxicating drinks and drugs that are injurious to health. Article 48 to prohibit the slaughter of cows, calves and other milch and draught cattle and to improve their breedings. Last, we have the liberal intellectual principles. They accentuate the belief system of radicalism and slope down the free and unbiased thought process. It should benefit the resident under the steady supervision of the law. They direct the state through Article 44, 45, 48, 48A, 49, 50 and Article 51. Now, what is Article 44? To secure for all citizens a uniform civil code throughout the country. Article 45 to provide early childhood cares and education for all children until they complete the age of 6 years. Article 48 to organize agriculture and animal husbandry on modern and scientific lines. Article 48A to protect and improve the environment and to safeguard forest and wildlife. Article 49 to protect monuments, places and objects of artistic or historic interest which are declared to be of national importance. Article 50 to separate the judiciary from executive in the public services of the state. Article 51 to promote international peace and security and maintain just and honorable relationship between nations to foster respect for international law and treaty and obligations and to encourage the settlement of international dispute by arbitration. Now coming to the directive principle of state policy and the Indian judiciary. The Indian judiciary has played a very important role in evolution of directive principle of state policies. Following are the judgments which have played an important role. First is the Kerala Education Bill of 1959. The court said that if a conflict arises between a fundamental right and a directive principle, the harmony between the two should not be disturbed. But even if after applying the doctrine of interpretation, the conflict doesn't revolve, then the former should be upheld and given more importance over the other. That is the directive principle of state policy. The next leading case is Madras versus Chamkan. If any law is in contravention to the provision mentioned under Part 3 of the Indian Constitution, it would be held void. But this is not applicable in case of directive principle of state policy. This shows that fundamental rights are on a higher pedestal than the directive principles of state policy as far as this case is concerned. The next important case is Venkatraman versus State of Madras of year 1966. The court gave more importance to the fundamental right over the directive principles of state policy. In case of I.C. Golaknath and others versus State of Punjab and other, the cases of 1967, the court held that Parliament cannot curtail the fundamental rights in making any law or policy for the country. It also mentioned that if a law has been made to give effect to Article 39 Clause B and Article 39 Clause C of Part 4 of the Constitution, and in doing so, if Article 14, Article 19 or Article 31 gets violated, then it cannot be declared as void merely on the ground of such contravention. Keshwananda Bharti versus State of Kerala, AIR 1973, Supreme Court, page number 1461. The apex court placed directive principle of state policies on a higher position than fundamental right. After that, in case of Minerva Mills versus Union of India, cases of 1980, Supreme Court, page number 1789, the court, while deciding the case, held that the harmony between the two should be maintained because neither of the court, while deciding the case, held that harmony between these two should be maintained because neither of the two has any precedence over each other. Both are complementary to each other and they should be balanced anyhow for the proper functioning of the state. The next important case is Unikrishnan versus State of Andhra Pradesh, AIR 1993, Supreme Court 2178. The court was of the view that fundamental rights and directive principles are not exclusive but complementary to each other. The court said that fundamental rights are the way through which the goals given in Part 4 can be achieved. Now, I'll be telling you what is the importance of directive principles of the state policy. The directive principle of the state policy play a very important role in the development of the country. First is the financial rights. Fundamental rights accommodate political rights. Directive principle of the state policy supplement them by accommodating social and monetary rights. Next is the sustainable development. Directive principle of state policy act as a standard for government assistance in India. Directive principle of state policy are significant as it tries to maintain harmony between financial advancement and rivalry on one hand and natural supportability and social and monetary value on the other. Next is inequality. With technological advancement and globalization, imbalance have expanded as reflected in the Oxfam report, which state that India's most extravagant 1% holds over 40% of national riches. Progress from the communist society to one with advancement and market economy where disparity will undoubtedly surface, the state must decrease these imbalances through assessment structure, endowments, different government assistance plans and so on. Next is important is responsibility. Directive principle of state policy are significant as it permits the resident to hold the legislature responsible in their strategic plan and execution. For example, the government has the responsibility to ensure correspondence at work, minimum wages and so forth. Next important is reasonable market. Globalization depends on rivalry and monopolistic propensities in market. Directive principle of state policies are imperative to provide free enterprise business condition to ventures. Human rights. Liberalization and private enterprise have little respect to the human workplace, compensation and work concerns. Directive principle of state policies are essential to providing and accommodating work value, equivalent wages for equivalent work, and improving the way of life of the laborers. It likewise ensures cooperation of laborers in the board of businesses for better harmonization between laborers and the modern intrigue. Human capital. Modern enterprises look for efficient and effective work from market having required aptitude and instructions. Directive principles of state policy put a commitment concerning the administration in providing free, obligatory and quality training up to essential level and improving the general well-being. Surroundings. Further, it obliges the administration to secure and improve the earth and protect woods and untamed life in the period of aimless abuse and deforestation-based globalization. Women's right. Liberalization and globalization have promoted women's empowerment. Directive principle of the state policies put an onus on the state to move in the direction of women's instruction, equivalent chance, equivalent wages, uniform common civil code and like that would additionally enhance the women's right. The Triple Talaq Act was a step to ensure the same. Now coming to the criticism of directive principles of state policy. First is its non-justiciability. The non-justiciable character of directive principle of state policy means that most of them have remained merely as pious declaration. The illogical arranged. The directive principles are neither properly classified nor logically arranged based on a consistent philosophy. The way they are arranged mixes up relatively unimportant issues with the most vital socio-economic issues and the modern issues with the old issues. Next is the conservative in nature. Critics argue that the directives are mostly based on the political philosophy of 19th century England and are not suited for 21st century India. Next criticism is ignoring social realities. Some argue that the directive principle of state policies fail to address the complexities of India's diverse socio-economic realities, resulting in policies that may not effectively address the needs of all citizens. The constitutional conflict. They lead to a several kind of constitutional conflict, as can be seen below, between the center and the states. The center can give directions to the state government regarding the implementation of these principles, and in case of non-compliance can dismiss the concerned state government. The conflict between the president and the parliament. The president may reject a bill that violates the directive principle of state policy. Next conflict is between the governor and the state legislature. The governor of a state may reject a bill that violates any directive principle of state policy. The conflict with the fundamental right. Some directive principle of state policy often conflicts with the fundamental rights, creating the challenges of balance competing interests. Now, what is the utility of these directive principle of state policies? Despite some criticism, the directive principles hold significance and utility for the following reasons. First is, they are the instrument of instructions. They function as the instrument of instruction or general recommendation to all authorities within the Indian Union and reminds them of the aim of building a new socio-economic order. Second, framework for state action. They constitute the overarching framework guiding all actions of legislative and executive undertaken by the state. Third, they aid the judiciary. They help the judiciary in determining the constitutional validity of a law. Thus, they act as a guiding light to the court. Next, they help to realize constitutional objectives. They elaborate upon and aim to realize the ideals envisaged in the preamble: justice, liberty, equality, and fraternity for all citizens of India. Next is the stability and consistency in the policies. They facilitate stability and consistency in both domestic and foreign policies across political, economic, and social spheres. They supplement the fundamental rights. They supplement the fundamental rights by filling the vacuum in Part 3 by providing for social and economic rights. They help to realize socio-economic democracy. By striving to establish socio-economic democracy, these principles create a conducive environment for citizens to enjoy their fundamental rights fully and properly. They help to measure the government performance. They serve as a parameter to measure the performance of the government. Thus, they aid the citizens as well as the opposition examine the policies and program of the government. Now, coming to the challenges in the implementation of the directive principles of the state policy. Now, what are the challenges? First is the lack of accountability. Due to their non-binding nature, critics argue that there is a lack of accountability in ensuring compliance with directive principle of state policy, allowing the governments to neglect their obligation. Second is the political expediency. There is a criticism that governments often prioritize short-term political gain over the long-term objectives outlined in the directive principle of state policy, undermining their significance. Third is the inadequate financial resources. Lack of sufficient financial resources is one of the prominent reasons holding the government from the fuller implementation of the directive principle of state policies. Next is the population explosion. Ever-increasing population of the country is breeding various new socio-economic issues which need priority attention. Thus, the implementation of directive principle of state policies keeps on taking a back seat. Strained center and state relationship. Inadequate spirit of cooperative federalism result in a lack of coordination and cooperation between the center and the state for the implementation of the directive principle of the state policy. Concluding the topic, the significance of directive principles of state policy cannot be looked down upon just because it is not enforceable in any court of law. These principles were added to facilitate the governance and smooth functioning of the country. It was added to meet the main objective and the ultimate goal of a country, that is to work for the welfare of the citizens. There are some important acts in the above mentioned information, so we can't say that directive principles of the state policy are not implemented and have no importance at all. It is like a structure given for the government, and it should work and formulate new laws revolving around that structure only so that the welfare of the people be ensured. Every policy and the law formulated by the state has to meet the standards which are mentioned in Part 4 of the Constitution. Thus, even after being non-justiciable, they are implemented in some important acts and they hold equal relevance and importance as fundamental rights mentioned in Part 3 of the Constitution of India. The expectation behind the incorporation of the directive principles of state policy in the Constitution is to make social and monetary majority rule system in the country, or eventually work for the government assistance of the overall population. These continue to be the directive for the state while making guidelines and strategies. Each such standard and provision should meet the standards which are observed in Part 4 of the Constitution. So, simply on the ground that they are not justiciable doesn't mean they are futile. Their significance has been consistently deferred by our apex court. They ensure that the state does not as an official courtroom but as an institution striving to serve their resident. Having said that, they are unquestionably helpful and give ground to the state government assistance, yet making them justifiable will serve no purpose, and in such a differing country like ours, it would give rise to net maltreatment by exuberant individuals. Their significance can be maintained if they remain conjured, mainstream and liberated from the moral statues. That's all for today's talk. See you in the next talk. Till then, thank you and goodbye.